Well, thank you everyone for joining us today for this presentation. This is the first of 3 presentations that we're going to be given over the next 3 weeks regarding commercial loan workouts. As you can see from our theme, we've titled this in the nature of a storm. We envision the pandemic as a storm that's battered the country and indeed the world, which will have and is having, obviously, tremendous economic effect on everyone and every business. And that to keep with the theme, we believe, and I'm sure you are fearing, that there will be a flood of defaults and workouts to come as the next part of this storm rolls through. The first presentation that we're giving today is on storm preparation, and that is preparing for the upcoming defaults and workouts that we know are coming. We can't see you, we can't hear you. You can obviously, I hope, hear us and see us. We do have a question and answer icon. If you are free to submit questions during the presentation, which we will see. Some of those questions we will choose to answer depending upon the question during the presentation, and if we don't address those questions during the presentation, we will be sure to answer them directly to you or to the group after the presentation. So no questions will be left unresolved at a certain point. I want to make introductions, so I'll go with myself first. My name is Christopher Currier. I'm a partner at the firm, and I have spent approximately 25 years representing banks in commercial transactions and workouts. I have been through a number of downturns and recessions where I have had to represent banks in connection with all kinds of problem loans involving, foreclosure, bankruptcy, you name it. Those lessons that we've learned from those other recessions will come around again, and we are prepared to deal with those problems. Rick?
Hi, I'm Rick Novak. I'm also a partner in Pierce Atwood's Boston office. I have the dubious honor of having worked on workouts and foreclosures since actually the early 1980s. So all of the last 4 recessions, I had the benefit of learning some new lessons. And while they're all a little bit different, they're all the same, and one theme of all of them is best prepared lenders are the ones who do the best. And so that's what this morning's about, or this afternoon's about, getting prepared for what can be some rough seas.
So the next recession is here. Before we put this presentation together for today, we were working on a presentation in early January, anticipating that the next recession was around the corner. There were a lot of warning signs out there, not least of which was the fact that we've had the longest recovery in history. And it was, given that our economy is cyclical, we knew that the next recession was likely to occur relatively soon. We just didn't know what the trigger would be. All of the recessions that have come before this one have been triggered by something, and I don't think anyone saw this one coming in such a dramatic fashion. As you know, because everyone's been paying attention, the unemployment rate is significantly high. Significant in the sense of 30+ million Americans are out of work, and it's increasing every day. It's the highest unemployment rate we've seen since records have been kept in 1948. And just to keep in mind, and to put it in perspective, in February, we had an unemployment rate of 3.5%. And the most recent tally, and it varies a bit by who you include in the metrics, but it's above 20% and increasing. So there is no doubt that we are facing a major economic problem, which will trickle down into your borrowers, their loans, and their businesses. We have levels of household debt we've not seen since the financial crisis of 2007. Commercial loans are in default. If they're not now, they will be. Not every commercial loan, but many of them will be. Some businesses may not survive this recession. We know that. We know that there are sectors of the economy that are especially hard hit. in connection with what's happening now. Restaurants being one of them, the hotel industry, to name just a few, and there are many, many others. There are very, very few businesses that are not being impacted by this extreme downturn. As you all know, because you've been spending a lot of time, I'm sure, over the past month or so working on PPP loans, that the government has stepped in to try and blunt the impact on businesses, but it's really going to be viewed as a Band-Aid for those that have even been able to take advantage of these loans. It's short-term, it's of limited impact, and once it goes away, it's clearly will not be enough to sustain businesses. It may help some businesses provide a bridge to reopening, but that really depends upon when things reopen. And Rick and I were discussing before we got online here that neither one of us view the recovery as V-shaped. It's very unlikely that things are going to come back online like a light switch. It's going to take some time. So a PPP loan that's providing some relief for 8 weeks or so is simply not going to be enough. So we need to take some time. You need to take some time now to do what you can to get ready for what's happening next. I think everyone's, like I said, been buried recently in understanding the PPP loan process, processing the PPP loans, and making the advances under those loans to your borrowers. But at last look, I believe this morning, the second round of the PPP tranche is nearly gone. So there may be another one. There may not be. There probably will be something, but again, it's, as you can see, it will not be enough. And the time to recover, who knows? It'll definitely be a long period of time. Certain industries will take longer than others. Some industries will never be the same. It's pretty clear. Rick, any comments there?
No, I mean, from the real estate side, it's the oldest joke in the real estate industry, but it's because it's true. The real estate industry is all about 10-year cycles and 7-year memories. And 7 years ago was 2013 when we were wrapping up the piles of workouts from the 2008 crash, and now there are a whole lot of people in the real estate business who've never seen a downturn, and there's nothing wrong with that. It just means we need to ramp up and get everybody ready.
Right. So we view this time now, after the PPP loans have been made, as an opportunity, and it's sort of a collective deep breath that everyone's taking. It's what will happen next. And we know there's, as I said, a flood of defaults and workouts coming. So now is the time, while this deep breath is taken, to prepare for that inevitable next step. So what steps can you take immediately? There are some decisions and choices that you probably have already had to have made. That is, when stay-at-home orders were issued and businesses closed, I know anecdotally, personally, and elsewhere, that many borrowers reached out and tapped into their lines of credit. And so you've had to face those questions already in many cases. But that may not be over. Any kind of discretionary lines of credit, you have to decide whether or not you want to make those advances, knowing that the consequences of making them, or not making them rather, could be the death of the company because of the impact it will have on them. But the ultimate question for a bank is, will it get repaid once it makes that discretionary advance? There are other issues with respect to committed lines of credit, such as construction loans, where there's a discrete set of criteria for making those advances, and you have to examine your loan documents and conditions very carefully to determine whether or not only you have the ability to decline making an advance under those committed facilities, but also whether it makes sense to not make an advance, given what the money may be used for. Rick and I were discussing the fact that some construction projects, it may be appropriate to make an advance to, button up a project, for example, just to mothball it for a period of time. It really depends upon the circumstances of each loan and each, construction project what have you.
Right. It's a really good exercise in critical thinking. Taking every loan you're looking at and saying, how does it look today? What's wise from the standpoint of protecting the bank's shareholders in terms of this loan? It's very easy to fall into the trap of, well, we have to put out more money, otherwise the project will die. Maybe that's in the best interest of the bank. It often isn't, and it's definitely premature today in early May to be making those sorts of decisions, but that ought to be part of the thought process for every single loan. What's in the best interest of the bank?
That's right. And I'm sure you're also dealing with a lot of requests for deferred payment agreements. So a lot of your borrowers were contacting you and saying, for example, our tenants are not making payments and we are not able to make payments under the loan. So we're looking for a deferral for the next 3 months. It's important that you agree to those things because it's probably appropriate in many cases to agree to that deferral, but it's equally important to document it appropriately. So an email, a paragraph is generally not sufficient. It has to be very clearly drafted. The terms have to be articulated very clearly in terms of how and when the deferred payments will be repaid, either on maturity, whether interest is made up when payments resume over some period of time, whether you have escrow payments are going to be required to continue to be made during the deferral period, et cetera. In addition to those terms, there also should be some, what I would call, or attorneys would call, boilerplate language that's designed to protect the bank, such as, we wrestled initially with whether or not it was appropriate to request a waiver and a release of claims in connection with the deferral agreements. And the answer is yes, it is. You, the bank, are giving something to the borrowers. You're forbearing or deferring these payments, and in return for acting in that manner, you should get something back in return for the borrower. So it's not only the release of claims, but it's also things like electronic signature provisions, et cetera. So again, very carefully drafted agreements are important.
Right.
Go ahead, Rick, sorry.
Well, I was just going to say, there's been a lot of talk in the post-2008 era about know your customer, and you've all spent a lot of time on know your customer documentation. Well, a recession is when you really get to know that customer. And you'll find that your borrowers will separate out into two groups. The good borrowers, these are people who they're in trouble because their tenants aren't paying them. It's a good project, and they're turning over all the cash. They're doing everything they should. They're giving their reporting. Those borrowers you definitely want to work with. There are other borrowers, they may have taken you on 15 golf trips in the last 15 years, but as soon as things turn bad, they're going to start hiding the money. And you'll find out that they are not your friends. And that's not evil. There's nothing wrong with that, but you need to deal with the two different types of borrowers differently.
Yes, correct. And the overall point here is to develop a plan to deal with the problem loans. So you should be thinking about the ones that are keeping you up at night now just because of the nature of the collateral or the borrower or the loan itself, the exposure, et cetera, but also by category, as I said, with respect to the businesses that are especially hard hit at these times, such as restaurants. I've had, worked on many, many restaurant loans, and when times are good, they're great. And in times like this, they're obviously a real problem. So consider examining your portfolio by, quote unquote, the worrisome credits because of the nature individually of those credits, and also by category. So we should probably develop a list of categories and questions about what the problems may be going forward with respect to collecting loans by category. Develop a plan of action. How are you going to collect your loans, and understanding that many of your borrowers will be in default, whether by covenant or by payment. You're going to have to deal with it. So consider now what you might do, what your exit strategy might be, and identify, as we'll talk about in a few slides coming up, what to do with your loan documentations in the meantime, your loan documentation, that is. Question that someone may raise is, do we make demand now if we have a loan in default? It's a question. There are, I'd look at it on a case-by-case basis, but you're not really going to be able to take collection efforts. Foreclosure for commercial properties right now in Massachusetts, there's no legal moratorium on foreclosure, but there's a de facto moratorium because there's a stay-at-home order in place, so it's considered commercially unreasonable. At least most people are viewing it as commercially unreasonable to hold an auction. Who's going to show up, even if they social distance? And to put a fine point on that, title insurance companies have taken the position that they will not insure those titles coming out of foreclosure because they consider that they're not commercially reasonable. Set off is another question that you'll face in terms of whether or not to set off accounts in connection with a defaulted credit presently. You have to look to your loan documents to see whether or not you have that right. That's a whole nother presentation in and of itself, but that's something you're probably grappling with. And also into whether you're not to enter into a forbearance agreement now or wait. My quick analysis of that is wait, because you need to, as we'll see in the coming slides, you need to know what you want and what you need. And those things should be built into your forbearance agreement. And you probably don't know those answers right now. So you have to take the time to figure out what those questions are, how to answer them, and then deal with the forbearance arrangement.
I agree with Chris completely that now is not the time to make demand. It's not effective. It's premature. To the extent that the borrower is going to come up with a credible plan, you need to give them a chance to do that. The one exception being, the known bad borrower who is diverting cash flow. You always need to move quickly on those people. But anyone else, you need to think it through first. And even if you did a foreclosure tomorrow, you'd get the property back. That's no prize.
Right. So as Rick said initially, that there's a famous quote attributed to Mark Twain, which is history doesn't repeat itself, but it often rhymes. As we said at the beginning of this, that these problems that we faced in the last recession with respect to our problem loans and how they were worked out, we'll likely see very similar issues this time around. So nobody should be surprised when they encounter them. And again, that's the reason why to start looking at what those problems might be in your existing loan portfolio, and use the opportunity to develop a strategy. And obviously look at your borrower's business, its management operations, et cetera. Now, as we just said, we would like to use this opportunity to fix any problems that you're going to encounter in your loan portfolio. And that would probably be most appropriate in a forbearance agreement or any other agreement that the borrower may be asking you to enter into. So what are some common issues that we've seen in the past and will likely see again? We're titling loan documentation issues as the self-inflicted injuries. Those are the ones that are lurking in your loan documents for one reason or another, that we've seen time and time again when faced with a workout. And before you pull the trigger, make demand, start foreclosure, et cetera, you have to know what you have so that you're not surprised and you can deal with the problem by correcting it if the opportunity presents itself. Some of those problems are, incorrect or inconsistent use of the names of the debtor in the loan documents themselves. I've encountered a situation where I've seen a note and a mortgage, be different, that the individual makes the note and the company who owns the property grants the mortgage, and the mortgage secures the note of the mortgage, the mortgagor, the company. You have to be careful for things a bit like that. Defaults should be consistent in all of the loan documents. We've seen situations of, demand loan with, a credit agreement, which has enumerated defaults, and you think you can make demand, but you may not be able to, unless there's obviously a default triggered under the terms of the loan agreement. Incorrect specification of obligations secured by the collateral documents. Again, that kind of speaks to what I just talked about. We've seen situations of lenders using Fannie Mae mortgages to secure commercial debt, which you want to avoid because Fannie Mae mortgages contain provisions which are inconsistent with a commercial loan, such as the right to reinstate, the right to cure over periods of time, and particularly where you have a demand facility. How do you cure a demand obligation once you've made demand? So avoid those problems. And we see a lot of those problems when lenders typically, it may be a smaller credit where a loan officer himself or herself documents the loan and, for one reason or another believes Fannie Mae mortgage is the appropriate mortgage to use. So you got to avoid that. Incorrect names of debtors on UCC filings. Again, we could spend an entire presentation on an Article 9 and how to correctly identify and name the debtor in a UCC filing so that it's correct. The danger, I'll remind everyone, is that if using the office where the UCC is filed, using their search logic, if you type in the quote unquote correct legal name of the entity or borrower, it does not show up. You're not perfected. So there's a lot of issues we see with UCC filings where you think you're perfected, but you may not be.
Right. The practical reality is that in each of the last 3 recessions, they were preceded by a period of extremely high transaction velocity. Lots of people doing lots of deals. Human beings, when they're going too fast, make mistakes. And so while today is not the day to be starting the foreclosure, today is the day to be reviewing your documents as if you were starting the foreclosure. Find out all those problems now so that you see them coming and get a chance to fix them.
Exactly. A couple other examples of mistakes we've seen that'll likely reappear this time is the description of the collateral in security agreement does not match the UCC filing. Incorrect description of real estate in your mortgage versus what's contained in your title insurance policy. Your mortgage should match the legal description in your title insurance policy so that you have adequate coverage. There are situations we've seen where there's, for example, a golf course as collateral and take a mortgage on the entire golf course, right? But turns out there's a strip of land in the middle of the course that's owned by somebody else. And now you want to switch from a golf course to a development of some kind, and it doesn't work because you don't have the title to the entire property. Mortgage does not contain a power of sale. That's not a death knell, but it's pretty bad. You can still foreclose using alternative methods, but power of sale is the best and easiest. Notary provisions, just a word of caution. Again, with respect to these defaults, everyone will be examining your loan documents very carefully to find problems, whether in bankruptcy or otherwise, so that they can either have negotiating power or just because they're trying to trump your position and improve theirs. Notary provisions, if they're not properly drafted, can invalidate a mortgage. I'll leave it at that. That's scary enough. Guarantees, when you have a guarantee, avoid modifying guarantees if you're making new loans. Guarantees are typically drafted to reflect decades of case law and surety law, and you should not willy-nilly just change provisions of a guarantee. And we talked about clear rights of set-off already, so if you have questions about set-off, we can deal with that separately.
Chris, on the subject of guarantees, do you want to talk here about going for springing guarantees, or do you want to pick that up later?
Yeah, please do.
Well, one thing you may wish to examine in guarantees is upgrading the guarantee to a true springing guarantee, CMBS type, because if the loan becomes in trouble later, you may have a dance about whether or not the borrower entity is going to go into bankruptcy. And if a credit-worthy guarantor is on the hook for a full springing guarantee, i.e. a guarantee in which they become liable for the entire debt if someone interferes with the foreclosure, you'll have a lot more leverage because that control party will cause the entity to stay out of bankruptcy. That's why the securitized world insists on springing guarantees, because they work. And if you can get it now as part of the workout, it doesn't actually cost the debtor any money.
Right. And on that point, did we mention lockbox as an example of something else a lender may ask for?
Right. We haven't talked about it yet, but again, part of the problem in doing a workout with a cash-strapped borrower is, in point of fact, they may not have any more cash to give you. They may not have any cash. They may not have any other assets. But there are things you can get in the forbearance or in the early workout that don't actually cost the money, but are very important. Upgraded financial reporting, upgraded guarantees, and as Chris said, a lockbox. If it's a type of collateral that involves a lot of money handling, A lot of borrowers have resisted lock boxes because they are difficult, but lock boxes are what you need during a recession, particularly in a cash handling type of debtor, because they may divert that cash and use it as a war chest in an upcoming bankruptcy.
Right. So now the next slide, I want to talk about some perfection and priority issues with respect to personal property. And again, these are issues that we've seen in connection with other recessions and workouts, and to be mindful of them when you're examining your loan documents and determining how to proceed with a problem loan. Again, the overall comment here is that a UCC filing covering all assets of a debtor may not be sufficient for the collateral that you believe you have. I'm sure many of you are experienced lenders and know this, but I think it's useful to quickly review certain perfection methods that are required in order to obtain certain types of collateral and have a security interest in them. Deposit accounts at other financial institutions are an example. Of a deposit account at another lender's office or a brokerage account, et cetera, is perfected by control. That is a control with the party who's holding the account, an agreement rather, with the party holding the account, giving you, the lender, secured party control over that account in the event of the occurrence of a default. Titled vehicles and yellow metal. So picture a contractor with a backhoe. Those pieces of equipment generally are capable of being titled, and the general rule is that if a vehicle is capable of being titled, then you may want to insist that it be titled and that you, the lender, take the title and be added as a lien holder to the title. The danger is this: if you go to closing and they're not titled, your UCC filing will cover them. Problem being that they could then subsequently get a title to the vehicle and add someone else as a lien holder. The party that's added as a lien holder to that title would trump your UCC filing. So something to be wary of. Patents and trademarks require, their unique collateral requiring unique perfection with the U.S. Patent and Trademark Office. Liquor licenses, I'm sure many of you have dealt with them in terms of the perfection going through the Alcoholic Beverages Control Commission and the local boards in order to obtain approval. You're not perfected unless you obtain those approvals. Taxi medallions, some lenders may still be making them, but there's special perfection methods depending upon the location and the jurisdiction that have issued the medallions. Stock in a corporation requires a pledge, and if there's a stock certificate, the stock power form and taking possession of the stock is the way to perfect. Investment accounts, again, investment accounts would be very similar to the deposit accounts above. Membership interest in a limited liability company, you have to determine whether or not that interest, that limited liability company interest, is certificated or not. If it's certificated, it would be certificated under Article 8, and it would be akin to a stock in a corporation, requiring that you actually take the certificate. Otherwise, it's considered something that you could file a UCC on. There is a danger there as well that it could be certificated after you take it, but you can put mechanisms in place to prevent certificating their interests. Tort claims is a different topic, not automatically covered unless they exist. And once they exist, you need to make a proper filing with respect to them. And they're only with respect to specific tort claims. Rick, anything to add to that?
Just that the liquor licenses are always a nettlesome problem, and they are a specific subset of permits. You may have a half-built project with a key Chapter 91 permit that they put in some other entity, and you don't have a hook on that. So, as you're looking at taking back a property, look at, do you really have all the permits you need to run it and to finish it?
Right, exactly. Now, I wanted to talk about some perfection and priority issues with respect to real estate. Rick, did you want to run with these?
We can talk about some of these. It's the construction aspect. Maybe let's jump ahead one slide.
Sure.
I think yeah. So any loan, but construction loans are the best example where the asset isn't there yet, tend to be the most problematic. Um, there's a whole lot of things going on. You need to make sure that you've got great confidence in not only your borrower, but also their contractor. There's a lot of opportunity for money to be diverted there. If the money gets diverted at the level of the general, you'll have to deal with the subs and their liens. So it's really an area where you need to invest a lot of energy, and particularly, and I think this is on the next slide, have an outside advisor unless you have really outstanding construction staff internally at the bank. It's very useful to have external construction experts talking about what you should fund and what you should not fund, and when. And that person not only brings expertise to the table, but that person also brings credibility. If there's a firefight later, you can count on the borrower saying the reason you didn't fund X for the construction was the lender was a bad person and didn't like the borrower. And what you want is an experienced, seasoned professional who can say, wait, I've built 50 projects like this, and continuing ahead on the restaurant portion of this when there was no restaurant coming in is it very important to have in litigation. The other thing about construction is that you need to look at your exit strategy right up front. I worked on a lot of workouts in Florida in the last recession, and they were buildings that came in 300 unit slices, and there was really no point in finishing them. There was no market and wasn't going to be a market for 5 years for those condominium units. And so shutting down the construction, buttoning up the building, mothballing it, it was a tough decision, but it was the right thing for the bank shareholders. So
Yep.
I don't know what you want to add there, Chris.
Yeah, I'll just drill down on some of the other aspects of real estate and construction lending. That is, in a construction scenario, these are considered committed lines of credit. I'm sorry. There's a distinction rather between committed and discretionary lines of credit. A committed line of credit typically would enjoy, with respect to each advance made under that loan, the same priority as the first advance made under that loan. That's because all of the money is committed at a time that you're entering into the facility. So you're generally considered for each advance to enjoy the same priority. With respect to discretionary advances, each advance does not enjoy the same priority as the first advance. A construction loan is considered to be a discretionary facility. That is, there are so many conditions for advance, or at least there should be so many conditions for advance that it's ultimately considered to be discretionary. In that case, you need to do title insurance rundowns in connection with each advance. Sometimes lenders might skip one or two just because they know things are going well, but they shouldn't, as Rick's head nod indicates. You really should be getting the title updates each time, because that is the built-in feature to determine whether or not things are going off track or there's a problem. So not only does it protects your priority with respect to the advance that's made, but it also tells you whether or not problems are developing. And those are early warning signals, particularly where advances are made on a monthly basis. So yeah, you should not avoid doing that. It happens, but you should not do it, particularly now. And just to put a fine point on that, so you make an advance on the first day of the closing for $100,000. A month later, you go to make another $50,000 advance. You don't do your rundown. Lo and behold, the money goes out, and then you find out that someone's filed a lien on the property in the intervening period. Your $50,000 is junior to that lien that jumped ahead of you. Cautionary tale with respect to real estate and hotel receipts. We came across this one where someone might be tempted to file a collateral assignment of leases and rents and assume that hotel receipts are covered thereunder. They are not. They're considered to be a receivable or just a payment. So a collateral assignment of leases and rents may not cover you. So I would do both as a cautionary approach. Would be to file a collateral assignment of leases and rent and a UCC filing covering all assets of the hotel. MLCs are an interesting topic, which we could spend another session on, but I've seen where MLCs are relied upon as the end-all be-all in terms of whether or not tax liens exist. They do not. Be very careful, because many municipalities sell their tax liens, and when they do, they sell their tax liens to a third party who will then step into the shoes, essentially, of the rights of the municipality and foreclose their tax liens. And because the municipality has been paid by the third party, they will show a clean MLC. But in fact, a tax lien still exists and must be dealt with. Condominium liens present an interesting problem. We know that there are, under the appropriate circumstances and proper procedures, a condominium lien can trump a mortgage if the procedures are followed, so be wary of those. Rick talked about mechanics liens, and railroad rights of way are unique. So generally, if we see a railroad next to a property, it is worthy of examination further to determine whether or not statutes that are implicated by such rights impact title. We talked about construction loans, or Rick did. I don't want to disparage contractors, but it's hard not to, having gone through the 2007, 2008 workouts. More than anything else, we experienced situations where developers were using money advanced for one project for another, where they were financed by different banks. I like to think of them as an example, or kind of an illustration that Michael Lewis put in his book, Boomerang, which was consider a table full of money in the middle of a room and no one's looking, and what do people do with it? Well, contractors will grab it and use it for whatever project is screaming the loudest and needing the most attention. So be wary of that. That's, again, a reason to do your rundowns and to closely follow those advances and the project. Let's see. Other condominium issues with respect to real estate in general is that be careful what you have or what you believe you have as collateral. I had a situation where a lender contacted me and said, please start foreclosing on the last units in this condominium development. And the units were nearly built, but it turns out that the mortgage at issue covered not the units, but just the development rights of the developer. So foreclosing on development rights versus foreclosing on completed or near completed units is a whole different kettle of fish. One other cautionary point I'll make with respect to condominiums is that there is a little known law in Massachusetts that's specified here that states, in the event of a foreclosure upon a condominium development, the mortgagee foreclosing essentially steps into the shoes of the developer with respect to problems in the project. So never leap before you look with respect to the foreclosure of a condominium development for those issues.
Well, and Chris, even without that statute, if the condo has been converted in Massachusetts and even 2 or 3 units have been sold, you've got a completely different foreclosure than if you're foreclosing on the box, because now you've just bought into part of a democracy, and you are the deep-pocketed person who's going to solve all the problems. So the 2/3 built and partially released condo is one of the worst things to have to take on, and it requires an awful lot of care.
Yep, absolutely. And also, when you look at, if you're foreclosing on development rights, they're only as good as they're drafted in the underlying condominium documents. So if you look at your condo formation documents, and development rights are pretty scant, could be an issue. No one may want to buy them because you're not sure exactly what you're getting. So that's why you have to examine the condominium documents in such a loan initially very carefully before even making the loan, but particularly where you're about to try and foreclose or work it out. We talked a little bit about set-off rights, so I'll just highlight this very briefly. Your loan documentation must be very clearly specific with respect to rights of set-off. It doesn't exist generally unless the obligation of the borrower is due. So you can only set off without specific rights if the obligation is due, meaning that For example, if a loan payment is past due, but you haven't accelerated, you can only set off with respect to that loan payment. They have to be essentially canceling. So lawyers generally put in very careful language in security documents about the rights of set off, and you should really avoid trying to tinker with those. A lot of borrowers do, but they can be very important, as you've probably seen and will see, particularly where if there's a trustee process action where a third party, and there will be plenty of lawsuits coming up with respect to defaulted obligations between creditors and borrowers where they haven't paid all of their bills. A creditor will try and trustee process the bank accounts of your borrower. And if you don't have the right to set off before you report back what's in the account, you may find that the other creditor who's now unsecured is secured with respect to your most liquid asset, your cash of your borrower. So be very careful about those provisions, and if necessary, tighten them up now or expand them, however it works, but you want to have the most flexibility with respect to them. So I think that's an important point.
Another argument for the lockbox right there. You just made it perfectly.
Right, exactly. Good point. Okay, so another example of problems that we've seen in the past is the relationship between affiliates. So many construction or just generally real estate loans where you have a property company, an entity that's an affiliate that owns the real estate, and an operating company that operates the business out of that real estate. And there's generally a lease between the two. But you're probably making a loan to both in some cases, where you have a real estate loan, which you've it's an acquisition loan or a refinance of a prior acquisition loan, and a line of credit, for example, to the operating company. Many people, and I've seen this time and time again, where there will be an SNDA, a subordination, non-disturbance, and attornment agreement. And that is, the bank will agree, and this would generally be used for third-party leases that a lender would want to keep in place in the event of a foreclosure. But keep in mind that in the circumstance of affiliates, Propco and Opco, if one loan is in default, then they should be cross-defaulted, and you're foreclosing and collecting on both loans. You do not want to be in a position where you are not able to disturb the tenancy of the operating company on a foreclosed property with respect to Propco. Sometimes those leases may be under market because they're between affiliates, and you could be faced with a situation of foreclosing on the property but leaving Opco undisturbed, paying the extremely low rent. And really, if you have this agreement, there may not be anything you can do about it. Practically speaking, presently, as I said early on in this presentation, there may not be an opportunity for you to evict Opco, even if this is set up properly. Assuming we get back to a situation where foreclosures, and they will happen again, you foreclose. Presently, right now, the courts are not accepting any kind of eviction actions. So even if you were able to foreclose presently, you wouldn't be able to bring an eviction action against Opco if they were in default under the lease or otherwise just subordinate to your mortgage. At some point, that will open back up again after the shutdown is rescinded, but only time will tell. So options are limited presently, but they will be opening up again. And again, it's time to examine what issues you may have so that they can be addressed now.
Right, and this Opco situation is just a specialized version of a problem that you have with every loan where there's a tenant involved, which is most of them, or multiple tenants. Which tenants do you want? Which tenants don't you want? Which tenants must you take? Which tenants can't you take? One thing you can do, even in an effective eviction moratorium, is it might be in your interest to terminate that below market lease. And while I meant terminate under state law if the lease allows it. You won't have possession. It won't help you on eviction at all. But if that tenant then goes bankrupt later and you have previously terminated their lease under state law, there will not be a lease left for the bankruptcy trustee to assign or assume or give you trouble about. So always keep that in mind when you're dealing with a weak tenant.
Right. Thank you, Rick. So that takes us to the end of our slides. And Rick, are there any questions we want to address?
I've been trying to answer them along the way. There were a couple of questions about Massachusetts municipal liens, and maybe I can try to talk about that for a minute and hopefully bring some clarity to it. The Massachusetts municipal lien statute says that if you get a municipal lien certificate from a municipality and record it within the time period, which is, I believe, 120 days, that operates to discharge all Massachusetts real estate tax liens, which are not already of record. And that last part is the most important part, because if there's a tax lien out there from 10 years ago, the municipal lien certificate has no impact on that at all. And if that prior lien was sold off record to somebody, well, in theory, there should be an indication that that lien was sold off record, but maybe there won't be. But the evidence that there is a lien out there for you to deal with will be on the record in Massachusetts. And frankly, if you funded behind that tax lien and didn't deal with it, that's a loan problem that should have been dealt with before and should be cleaned up now.
Yeah, no, a good point. Yeah, the warning there is not to just simply look at your municipal lien certificate and assume that you're fine. You need to examine the entire record to determine whether or not there's an issue.
Right. Something to talk about in Massachusetts is the relative subordination of leases and priority. If you foreclose a Massachusetts loan and there's a lease that's junior to you, so let's say you closed your loan in 2014 and the lease went on in 2015, unless you've got a subordination and a term agreement with that tenant, the foreclosure of your loan will automatically terminate that lease. And if that's a very valuable lease to a deep credit, like say Amazon, that isn't going to go anywhere, you effectively can't foreclose because you'd be killing the income to the property. So again, this is all part of think ahead, look ahead, play out all the scenarios and plan carefully because sometimes you would be all set to foreclose, but you just can't kill that one lease.
Right. So, all right. So any other questions, Rick, or are we?
I think we've got there was another one on, someone was asking about the duration of condo liens. And I think we were talking about, again, in Massachusetts, there are condo liens for unpaid condo fees. But I think the liens that Chris and I were trying to warn you about were the ones about being stuck with delivering on a developer promise. And my view has always been whether or not there is a statute that says you have to do that. As a practical matter, you're going to be stuck with it. One of the important dynamics of any workout is what we call the weakness of strength and the strength of weakness. And as the foreclosing bank that has the assets to be able to fund the problems of the condominium, you will have the weakness of strength. Everybody will come to you looking to solve it. And the developer and the or the individual unit owners have the strength of weakness. They have no money, but they can all call their local representatives and the banking commissioner, and you're simply going to have to deal with those people. It's one of the reasons why people don't like taking over condominium projects. And Jack Manheimer raised his hands. Jack, I think you need to send a question on the question list. Jack is our bankruptcy partner up in Portland, very smart guy, good guy. I just don't know what he's trying to say.
Yeah, he's there. Let's see. I don't know if we can unmute him.
Julie Biggers, can you unmute Jack? Make him a co-host.
Can you hear me now?
Yes.
Yes.
Okay, good. Thank you. I just wanted to comment on a couple of nuances under Maine law. and actually some differences under Maine law that some of our Maine bankers may be thinking about. The first was that unlike Massachusetts, liens of condo associations do not trump mortgages in Maine, which I think is an important distinction. Now we're not talking about the situation where you have a partially completed condominium project. I'm just talking about the situation where you're foreclosing on a unit in a condominium and the condominium association has a lien. That lien is junior to your mortgage, assuming that your mortgage is recorded ahead of the condominium lien. Then on the subject of municipal lien certificates, in Maine, I'm actually not familiar with an active market in the purchase and sale of municipal tax liens. And we're pretty confident in Maine that we know from a registry search whether there are tax liens that need to be addressed as part of any workout or restructuring, something like that. And we can identify those. And the only way for them to be discharged is by discharge of record by the municipality. And if it takes place after 18 months after the lien goes of record, it needs to be in the form of a release deed as opposed to simply a discharge. On the subject of evictions, we also have an eviction moratorium in place pursuant to executive order and a Supreme Court order. But the extent to which it applies to commercial evictions and the extent to which it applies to writs of possession issued in connection with foreclosure matters, as opposed to straightforward lease termination and eviction proceedings, is an open question. And then lastly, with respect to foreclosure of income producing property with leases where you don't have SNDAs with your tenants, also not entirely clear that those leases terminate if there's been a valid collateral assignment of leases and rents to the landlord, whether the lease in fact gets terminated by the foreclosure, or whether the landlord has the right to enforce whether the lender has the right to enforce the lease under that circumstance. So just a couple of differences on Maine law that I wanted to point out.
Mm-hmm. Yeah, good points.
Right, and that can be one of the problems that comes up in a high transaction volume environment, is people, even though they're not supposed to, they reach out across state lines, and you've got Massachusetts lawyers using Massachusetts nominee trusts in New Hampshire, and that's a major no-no. Or people in Massachusetts trying to guess wrong on what Jack's pointing out up in Maine. So again, like reading your documents carefully, make sure that if it's a jurisdiction where your bank doesn't usually work, that you had everything exactly right.
If I'm still not on mute, there was one other question. Will the slides be available after the call? And the answer to that is yes.
Correct. I sent that. Hopefully the entire group saw that.
Oh, okay.
Okay, well, I think that's it. It's 12:56. And so I think we're good for now. You have our contact information here on the last slide. So if you have any further questions you want to discuss with us, please feel free to reach out to any of us. And you have our emails and phone numbers and Jack's cell phone number as well.
All right. Thank you all very much for your time today. And we all wish you every success in the great challenges coming ahead, because they're coming.
Thank you all.
Thanks, gentlemen.